Hi, everybody. I'm Diane Brady. I am here with Alan Dershowitz, noted trial lawyer, Harvard professor emeritus, author of Get Trump, which is the perfect background, Alan, I think, to talk about Trump and this civil fraud trial. What do you make of it so far?
Well, I named my book after this case. That is, it was Letitia James who campaigned on the promise to get Trump. And this is simply a manifestation of keeping that promise. She has to get Trump or she won't get reelected. She could have gone after any one of 1,000 real estate moguls in New York and prove that they had overestimated the value of some of their holdings. It's very common. Certainly, she could prove that they evaluated the holdings more than the estimates for tax purposes, but they targeted Donald Trump. They went after him only because of who he was. You know, the Bible says to judges and prosecutors, do not recognize faces, do not ever make decisions based on who the person was. Is there anybody out there, anybody who believes that this case would have been brought if Donald Trump were not the former president and the current leading candidate to run against Joe Biden? Of course not. This is selective prosecution, and it's wrong.
Could you argue, as the New York Attorney General has done, that the stakes are higher in this case because this is a man running for president as opposed to any other real estate developer in New York?
That's a serious mistake. Let the public judge based on the information that's available. You don't have selective prosecution. We do in many countries. You know, one of the dictators in South America said, for my friends, everything, for my enemies, the law. When you aim the law at any particular individual, the great Justice Robert Jackson once said, he was the chief prosecutor at Nuremberg and a justice of the Supreme Court, any prosecutor rummaging through the statute books and rummaging through the records, if any person can find enough to bring a charge against him. So this empty claim that no one is above the law, but no one is below the law. The law has to be applied equally to everybody, whether you're running for president or not. In fact, the fact that you're running for president and that tens of millions of people want to vote for you for president ought to be a reason for not bringing a case during the presidential election campaign season. You wait until after the election is over. You don't try to influence the election by partisan. And remember, all these people, Letitia James ran as a Democrat, Alvin Bragg ran as a Democrat. The judge, as far as I know, is
He's been listed as a Democrat, certainly.
Yeah, and the whole judicial system of New York is heavily dominated by Democrats and by anti-Trump Republicans. Remember, too, that some of the leaders in the Get Trump campaign are Republicans. Now, I'm not a Trump supporter. I'm going to vote against him. I want to see the American people have the right to defeat him decisively in a real election that he can't complain about. And I don't think that we're seeing that now, because we're seeing so much influence being put on the election that if Trump loses, he's going to continue to campaign and complain and say, look, they indicted me 4 times. They took all my money away. They tied me up in court. And that's why I lost the election. I want this to be a clean, fair, open election, which he loses on the merits.
In terms of the trial itself right now, one thing that is surprising to some people is that he has shown up. Are you surprised by that? Would you have advised him to show up given the conditions under which this trial is taking place?
I think it's wise for him to show up. The question is, should he take the stand? It's not going to influence the outcome of the case. The judge has already made up his mind, already gave summary judgment based on some statements about the value of property, particularly Mar-a-Lago. So his testimony won't help him. On the other hand, if he does testify, it might be a perjury trap. And if he says anything that Letitia James or Alvin Bragg think is not true, they can then up the stakes and go after him for perjury. So it's very possible he will sit there and growl and let his views be known through his facial gestures, but that he may not take the stand. He would have to plead the fifth in order not to take the stand if he's called by the prosecution. He can plead the fifth. He can say, I refuse to answer these questions in a civil case because they may incriminate me in a potential criminal case. He can say that, and that can't be used against him in the criminal case. but it can be used against them in the civil case. So there are reasons for not taking the Fifth Amendment. There are reasons for taking the Fifth Amendment. He may have to make the decision himself whether to take the stand, because the prosecution may or may not call him. If they don't call him, then it's his decision to take the stand. And if he takes the stand, he essentially waives his Fifth Amendment privilege.
One of the things that's been surprising is how bombastic the approach has been. And again, this has not been televised, so this is all based on what has been reported. But the opening remarks from his lawyers have very much been in line with his rhetoric, which essentially is attacking this as a political trial. Is that a wise strategy? I mean, as you said, to some extent, it's a fait accompli. There's been a summary judgment. On the other hand, you would think that being angry and bombastic in court is rarely a winning strategy.
Well, if he thinks he has a chance of winning, then it's not a good winning strategy. But if he knows he's going to lose, then he's really playing to his political base and continuing to make the arguments he's made before. Now, this judge has already sanctioned the two of these lawyers for repeating an argument he rejected. Lawyers should repeat arguments that are rejected. If they don't repeat them, often they waive them. So this judge going after the lawyers has tried to intimidate them. And I hope the lawyers won't be intimidated. There's a project out there called the 65 Project, consisting of hard left lawyers who are bringing bar charges against anybody associated with Donald Trump. When I complained about this group and said that I would defend anybody who they brought charges against, what do you think they did? They brought bar charges against me. And so they're going after every lawyer who has any association with Trump. I have no current association with Trump. I'm not his lawyer, but I was his lawyer in front of the United States Senate. And so the reward for that is having a bar charge filed against me. I have the resources to fight back. But the 65 Project said, let's go after weak lawyers, poor lawyers, lawyers in small areas, lawyers who don't have the resources to fight back, and intimidate them and make sure that they don't associate themselves with Trump. That is McCarthyism, pure and simple. And I'm going to fight back against that, even if it means bar charges against me. And I think there'll be bar charges against these lawyers as well, because this judge has made it a policy to sanction them for simply repeating arguments that he doesn't like.
You know, are you surprised that they didn't ask for a jury trial, given that this is a man who does play well to the crowd?
It wouldn't have made much of a difference, because the judge granted summary judgment that would have taken the main issues away from the jury anyway. I don't understand why they didn't ask for a jury trial. New York law is a little vague on all of those issues as to cases like this. But in general, it's always better to have a jury than a judge when the judge is so inclined against you, as this one obviously is.
Do you think there's much recourse if, given the nature of this particular law, which seems to be very specific, that if his license essentially to operate in New York and that of his sons is taken away, what are the odds of an appeal being successful?
Well, I think there's a chance that they could be successful in the federal court. This is, after all, a taking without due process. This is taking property away from him based on what seemed to me to be speculative assumptions. So I think he will appeal. Will he get a fair appeal in front of the appellate division or the New York Court of Appeals? That remains to be seen. I think it's more likely that he'd get a fair shot at the appellate level than at the trial level.
Have you encountered any other cases? I mean, I think, to me, just my vague coverage of New York real estate, it's very common to want to look beautiful to your lenders and pretty poor and miserable to the IRS or anybody trying to take tax from you. That dichotomy is something that's very common. Obviously, the size of the dichotomy here is pretty big in terms of the gap of what was stated one place or assessed and what was then stated to the lenders. Have there been other cases like this, or is this unique?
I don't think there's ever been a case quite like this. The Mar-a-Lago case puts it in perspective. The judge implied, he talked around it, and he cited the assessments that were done by Palm Beach assessors of $18 to $27.5 million. I think you and I should pool our money and buy it for
Mar-a-Lago.
then sell it the next day for 20 times that amount. I mean, it's an absurd figure even to mention in an opinion. Nobody would take that seriously. It's obviously worth hundreds of millions of dollars, not $27 million. Now, it may be assessed at $27 million, but I've also offered to buy the judge's own personal home in New York for what it's assessed at for tax purposes. Nobody sells a home based on the tax assessment. And so that's why banks hire at extraordinary expenses to them some of the best real estate assessors and accountants to do their own due diligence. Nobody counted or relied on this, which is the argument that his lawyers tried to make and were rebuked for. Nobody was hurt here. There was no intent to hurt anybody. There's no victim here. And generally, the state attorney general would be better advised to go after and protect real victims. Why is the state attorney general protecting large banks that have the ability to protect themselves? They're the last people that need the protection of the attorney general of New York. So this is purely 100% political and partisan.
To end, let's step back to the 30,000-foot view a second, Alan, because this is obviously one of several cases. I believe it's 91 charges that the former president's facing. What's on your radar? I mean, how does this really impact what else he is facing? I don't know if he's likely to show up for those, to TBD, I suppose. But what are you thinking about the overall landscape right now in terms of the legal challenges that Trump is facing?
Well, I hate to be advertising myself, but in my book, Get Trump, I go through each of the cases. In fact, I go through this civil case as well. And I predicted each of these cases, that each of them would be brought. Now, he has to appear at the criminal cases. He has no choice there. In the civil cases, he does have a choice. He's chosen to show up at least from the beginning, if he shows up in a continuing way. But the criminal cases, he has to show up, and he has to even show up and get on a plane to pronounce the two words not guilty. So they're using this as a way to keep him off the campaign trail. And as I said, I want a fair and open campaign so that when he loses, if he loses, he has no complaint. He can only say the American public decided. But that's not the way this is going. I think there will be convictions. I predicted in Get Trump. There will be convictions, and there will be reversals of the convictions. But the reversals will occur after the election. And that's the goal. That's the tactic being used by the Get Trump posse. Down and dirty convictions based on absurd indictments like the New York one that Alexander Hamilton could have gone to jail for not reporting the payment of hush money. Who has ever paid hush money knowing that
the Alvin Bragg one?
That is an absurd case, but he may get convicted because 75% of the jury pool will have voted against him, or the District of Columbia, where 90-something% of the jury pool will have voted against him. So there's a likelihood of convictions and of verdicts like this one in this civil case, the summary judgment, but also a likelihood that some of these will be reversed on appeal, but the reversals will occur only after the election, and therefore the tactic will have succeeded in having to make sure that the convictions occur before the election. Now, in terms of getting him the nomination, it's helping him get the nomination, not hurting him. But in terms of the general election, it might very well hurt him to have some convictions.
Much more to be discussed, and I look forward to discussing it with you. So thanks, as always, for joining us, Alan.
My pleasure. Thank you.